This is in theory.
Professor, how do you read the Constitution?
The American system is a clause-based system. To void a statute, you need a clause, a phrase, a sentence, a word. Note the difference between this. I'm voiding this statute due to tradition, due to norms, due to beliefs, due to polls, due to ethics, due to right reason, any one of these things, and saying the statute is void because it violates the free speech clause of the Constitution.
The natural law theorists always claimed that these pie-in-the-sky ideas, things that they would want to latch onto, that they were real in the legal system. And the positivists would deny that. They'd say the only thing that is law in the government is something that the government officially recognizes in some way.
You are listening to In Theory.
For example, this is the Second Amendment. The issue is not whether the right to bear arms is being violated. The issue is whether the clause is. Everyone see that difference? That's huge. It's not whether the right is being violated. It's whether the clause is being violated. Very important to understand that difference. Make sure if you understand anything that I've said in this lecture that you understand that distinction. Lots of people think that they have gun rights, but when you look at the actual text, it doesn't seem to grant it very liberally. In fact, what it seems to do is place a precondition. A well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. The argument is that today we've taken militia and we've institutionalized it. Militia is now the National Guard, or there's also police forces, if the only point of the right to bear arms is the security of the county, the polity, the state, the country, that therefore an individual wouldn't necessarily have this right today. So that's one way we can read it. Now, that's not the way the Supreme Court read it in a very interesting case that we're going to look at.
You are listening to In Theory.
Here's another one. Neither slavery nor involuntary servitude, except as punishment for a crime, whereof the party shall have been duly convicted, shall exist within the United States. Now, this is the 13th Amendment. It abolished slavery. But notice how interesting this is. Except as a punishment for crime. There's two concepts here. The right to be free, and the other is what the clause says. The clause seems to say that slavery is okay if you get punished for a crime. It seems to say that as a proposition. Now, this obviously is a repugnant idea. Prisons make people work. They have work programs. But nonetheless, this is rather controversial because on the one hand, we want to say what this says as an ideal versus what it says as a piece of text. There is a school of thought that says we should start reading the text, idealizing it, giving it an idealized read. We're going to go over that later in the course. That's kind of a postmodern way to do this.
You are listening to In Theory.
Basically, there are three different theories about how to read a plain language constitution. One is going to be originalists. We have to follow what was originally in mind when the thing was passed. And then there are going to be textualists, which you've got to focus on the proposition of the clause. Now, what does that mean? Well, we already talked about that when we talked about the 13th Amendment. As a proposition, the clause does not outlaw slavery if you're incarcerated, or if you've been convicted for a crime. And so because the clause says that as a proposition, that is a textual analysis. Another textual analysis would be as follows. You'd say that there is no right to bear arms so long as this precondition is met. It's based on a clause from which we try to derive a proposition. That is textualism. Now, the third school of thought is something called integrity theorists. And this, by the way, is what your professor believes in. I'm an integrity theorist, along with a fellow by the name of Ronald Dworkin. The point is that law needs to have integrity. If we're going to do the judicial business right and do judging right, that we've got to have it so that these interpretations, these constructions reach to a whole range of things. Look at history, look at text, look at principles, look at norms, look at morality, look at everything, and come up with the best read. And this means that the law has a lot to do with connoisseurship. Connoisseurship, that might be misspelled, but I'm not French.
You are listening to In Theory.
And that is what this book argues, that Supreme Court decision-making is an aesthetical project. By the way, we're not saying anything about politics here. What we're saying is that these are the three theories that are out there for meaning. Okay, these are meaning candidates, meaning theory, candidates for meaning. There is another candidate for meaning which is called skepticism, and that says that there's no truth here, that the Constitution doesn't mean anything. In other words, these people basically kind of just give up. They say there is no meaning here, and this thesis here is explicitly political. They think Supreme Court judging is about explicit politics. So these are the three views that there is a meaning. This view says there is no meaning. That basically is the theory for how to read a constitution. Let me do that again. How do you read a constitution? You're either going to be an originalist, a textualist, an integrity theorist, or you're going to say it can't be read. It can't be done. It can't be read. Okay? And I think that's probably a good place to quit.
See more of Dr. Wilson's lectures here.
Go to SeanWilson.us.